All right, we have some breaking news out of the Supreme Court for you. Supreme Court looking at a number of really consequential cases, and we have a decision on one. I want to bring in Ilya Shapiro. Ilya, you are the director of the Robert A. Levy Center for Constitutional Studies, and you're joining us. This case has to do with the Electoral College, and I'm going to kind of ask you to not just break down the case, but I think people may not completely understand the role of the electors and what they can and cannot do. So can you kind of give us a little bit of a definition as well?
Sure. Well, the Electoral College, as we've probably come to learn in the last 20 years, is the way we elect the president. It's not simply the winner of the national popular vote. Each state has the same number of electors as their combined representation in Congress, so senators plus House members. And D.C. also gets 3 electors. Now, these are supposed to be the voices, the votes of the people of that state when they're choosing the president. But in our history, we have had faithless electors, what's called, meaning those who have pledged to support, say, the Democratic nominee, but then go off and vote for someone else. And that, in fact, is what happened in 2016. 7 electors across several states declined to vote for either Donald Trump or Hillary Clinton, who won their respective states' popular vote, and voted for other people. The states of Washington and Colorado sanctioned such deviations, such faithlessness. And so the issue before the Supreme Court was whether states can indeed enforce the pledges of these electors to vote for the assigned party nominee that they're supposed to. 32 states have some sort of pledge laws like that, and 15 of them, including Washington and Colorado, as I said, enforce them with some kind of sanction. Well, today, the unanimous Supreme Court ruled that states can enforce their pledge laws, can punish people or replace electors or fine them if they don't vote for the nominee of the party that won their state. That's a unanimous opinion. Slight split on exactly why, with Thomas and Gorsuch saying it's sort of reserved to the states, whereas Justice Kagan and the rest of the majority said it's part of the Article 2 power for electing the president. But regardless, unanimous decision, states can punish electors that deviate from their state popular vote.
And so I ask you a little bit to explain, partially because, you know, we are on the air all over the world, 80 plus countries, and people may not be aware of the fact that here there is a difference between the popular vote, that it's not the popular vote leads directly to the president. There are a couple of steps in between, and so I wanted you to clarify that. And so when you read the decision of the justices, does it appear as if this is the last conversation on the topic, or is there legal wiggle room?
It's pretty clear. This is the thing. We've had faithless electors in our history many times. They've never been decisive in electing a president, but of course, ahead of the 2020 election, if it's going to be as close as it was last time, this is an important issue. And the court spoke decisively. And the whole opinion, including the Thomas Gorsuch concurrence, was 33 pages. I mean, very clear, very short, very logical opinion. Really no wiggle room. States don't have to punish their electors. They don't have to enforce their rules, and for that matter, Nebraska and Maine don't give all of their electoral votes to the winner of the state popular vote. They go by congressional district as well. So states do have options in terms of how they want to allocate their electoral votes. But once they've decided that, they can enforce that. The Supreme Court ruled today very clearly.
Okay, so before I let you go, I want to ask you about another case having to do with robocalls.
Yeah, that's the other case that was decided today. When the robocall prohibition to cell phones was enacted a number of years ago, there was an exception for government robocalls. That is, if the government tries to collect on your student debts or other debts that you might owe to the government, there was an exception. They could robocall your cell phone. Well, the court today ruled 7-2 that they cannot. That is, the exception is gone. The government stays in the same shoes as a private telemarketer or other debt collector. They cannot, if you said that, don't call me, then you cannot be robocalled in that way.
And then looking forward, we've sort of been on the edge of our seats because there are a number of big decisions that the court is expected to hand down decisions, a number of big cases, rather, the president and his taxes. Give me sort of a list of the biggies that you're waiting to hear about.
Yeah, the presidential tax returns, subpoenas from a congressional committee and also from the Manhattan DA. Those might work differently. We'll have to see. The ministerial exemption, that is, religious organizations are exempt from employment discrimination laws if the person is a minister, a teacher, or a religious advocate of some kind, generally not applicable to, say, janitors or something like that, but we'll get a definition of how broad that is. Little Sisters of the Poor, the group of nuns that didn't want to be subject to the Obamacare contraceptive mandate. That still is rolling around in the courts, and the Supreme Court will decide how the administrative law works in that way. And the constitutionality of Oklahoma, or at least half of it, might revert to being an Indian territory or a reservation of some sort. Very important issue, certainly for that state, but also in terms of how we prosecute murderers or other criminals in that part of Oklahoma.
Whoa, that is fascinating. That's one that's flying below the radar. We're lucky to have you, Ilya. Thank you very much.
Happy to be here. I'll be here all week.